today. I think we're going to have a few more join us, and I know some of you are still connecting the audio. So we'll get started here in just a minute with Catherine Reynolds, our guest speaker today. But first, I guess I'll just give a quick intro to anyone who's not familiar with the Small Business Development Center. We offer free one-on-one consulting services, as well as some of these educational sessions like this one we're doing today. So I'll put some links in the chat if you are interested in scheduling one-on-one appointments, whether it's about legal issues or HR issues with hiring or anything else. You know, we have specialists to help with marketing and finances and business planning and just all these different areas of your business. We are here to support and resource you. So today we're talking about how to hire employees legally. The workforce is changing. We know it's in a stage of a lot of movement going on. So a lot of people are looking to hire employees, and especially if you're looking to do it for the first time, you might feel overwhelmed. I know myself personally, I wouldn't really know what I need to do legally, and you want to make sure you get it right the first time in dealing with these matters. So with us today, like I mentioned, we have Catherine Reynolds. She's an attorney with Polaris Law Group and one of our legal consultants with the SBDC, and she has a lot of great information for us. We will be recording this session and uploading it to our video library later on this week, and we'll be sending out later on, we'll be sending out the slides, and Catherine put together a little resource handout guide as well. So we'll be getting you all of these resources. And if you have questions, feel free to put them in the chat. And then at the end, we can also do some Q&A if we didn't cover any of your questions there. So Catherine, I will turn it over to you.
Thank you, Hannah. Hello, everyone. So we're going to talk about how to hire employees legally, and I have a slideshow, which, as Hannah said, you guys will be provided. So if you have any questions, you can resource it. I've also pulled together resource materials, and it'll be a sheet that'll have links to a lot of the laws I'm citing in CDLE guidance. So if you have any questions, I'm doing a very high-level employment talk. We're going to talk about a lot of things, so you will have the ability to go back and look at specifics. So with that, there's still a few people trickling in, but given that we're on kind of a tight time schedule, I'm going to go ahead and get started. The presentation and any materials provided with it are intended for educational and informative purposes only. Neither these materials, the spoken presentations, nor any comments or answers given by myself or anyone from Polaris Law are legal advice. The materials, presentation, and comments or answers are not to be relied upon for your individual situation or business. Polaris Law Group, their attorneys and employees, and the SBDC does not assume responsibility for any reliance on the information presented in association with this presentation. Each individual attendee should seek professional, personalized legal advice before using this information. So, table of contents. What are we going to talk about today? What is an employee? What are the rules that govern employment and employee management? Additionally, at the end, I will do a Q&A. So what is an employee? An employee means any person, including a migratory laborer, performing labor or services for the benefit of an employer. Colorado, there isn't a presumption that anyone who works for you is an employee unless you have a written contract and that contract abides by the CDLE requirements. If you don't have those two things, then the people who work for you are employees and would fall under this law, all these laws. So, the main rules we're going to talk about is paid sick time off, which is a new Colorado rule. Paid time off, the Colorado Department of Labor and Employment recently updated their guidance on that. Equal pay for equal work. It's, again, another new Colorado law. Comps 37. Comps 37 is the Colorado Department of Labor and Employment's administrative rule that covers a lot of employment stuff, such as minimum wage, overtime wages, meal and rest periods, as well as exemptions. discrimination on both the state and federal law, Family Medical Leave Act on both the state and federal, Secured Savings Act, workers' compensation, payroll tax, and then wage transparency, which is again another Colorado law. Excuse me. So sick time versus paid time off. In 2020, as a response to COVID, the state of Colorado passed the Healthy Families Workplace Act. While part of this act is what you guys have probably already heard of, dealing with paid sick time for people who have tested positive for COVID, the more important and long-term is this required sick time for all employees in Colorado. Starting January 1st of 2022 for all employers, and then January 1st of 2021 for all employers with 16 or more employees, you will be required to provide sick time. How sick time works is it's 1 hour of sick time for every 30 hours worked, which equates to 6 days for full-time employees. That time starts hour one, day one. That time accrues and does carry forward year over year over year. However, you are allowed to limit your employees to be able to only use 48 hours per year. If you have a more generous PTO, vacation, other policies that allow them to take sick time, you don't have to worry about this, but this is the new minimum. As many of you are aware, Colorado kind of changed the requirements for paid time off and vacation pay. While this is not required under Colorado law, if you do provide it to your employees, you now must allow your employees to accrue 1 year's worth of PTO or vacation time. You can't, if you, for example, if they accrue 10 hours every month, you have to let them accrue 120 hours before you stop making them lose it. You can't do less than that. And then the other thing is, which has been law, this must be paid out upon termination for whatever the termination reason is. So you need to make sure that if you are offering PTO or vacation time, that you have the money to pay it out if and when you fire someone or someone quits. The other thing, and going back to the sick time that I didn't mention, unlike paid time off and vacation pay, sick time does not have to be paid out when an employee is terminated. So that's an advantage to sick time, is that you don't have to pay it out, unlike PTO and vacation pay. So again, in 2019, Colorado passed a very kind of reformatory act called Equal Pay for Equal Work Act. That's the abbreviation for it. So if you see it throughout this presentation, you know what I'm talking about. The Equal Pay for Equal Work touches many parts of our presentation today. I've done a previous presentation on equal pay for equal work, so if anyone has very specific questions on that, I'm sure Hannah can share the link to that. But what equal pay for equal work does is it prevents discrimination based off of substantially similar work based upon sex, which includes gender identity and or sex plus another protected status. So we have the sex, which includes gender identity, and a second one where if you have all employees but one who are of one race, and then you have another employee of a different race, you can fall under this Equal Pay for Equal Work Act. A lot of people are like, what does substantially similar work mean? Unfortunately, there's still not a ton of guidance out there on this. This has not worked its way through the Colorado Department of Labor nor the court system. But what it really is looking at your employees past their job title and see what each employee does and their duties, and then determining if you are discriminating on this. Something of note, which will be more relevant later, is that if an employer is violating this law and they are not determined to be in good faith, then you can be subject to liquidated damages and attorney's fees. Liquidated damages are double economic damages. So for example, if it were found that you were discriminating against an employee at a rate of $5 an hour for 40 hours a week for 3 years, because there's a 3-year look back period, but there's a statute of limitations for 2, then you could be subject to all of that back pay plus liquidated damages in the same amount, and attorney's fees. So people need to be aware of this act, and they need to be aware of what is going on. So exceptions to the Equal Pay for Equal Work Act. So you have this analysis where you must pay substantially similar employees the same amount of money, which includes benefits. There are these exceptions, and these are the only exceptions to paying similar employees different amounts of money, including benefits. One of those is a seniority system. One of those is a merit system. One of those is earnings by quantity or quality. So if somebody has a commission basis, or if they do so much work, geographic locations, that does not mean the difference between Highlands and Littleton. We're talking Aspen to Denver, or Denver to the Eastern Plains, large areas. And then travel. So if somebody is required to travel, and then education, training, or experience, if it directly relates to the work in question. If it is not on this list, you can't use it. So the other thing to be aware of is that these exceptions need to penny for penny reflect the difference in wages between two similarly situated employees. So if you pay one employee $1 more than another employee, you need to say exactly why that one employee is making $1 more than another employee. Comps 37, I mentioned this earlier. This is kind of the guidebook for day-to-day employment law in Colorado. The Colorado Department of Labor and Employment publishes these rules every so often, and then they update them. There should be, a new Comps 38 coming out. That'll include the new migratory laws and farm worker laws. So just kind of be on the lookout. Make sure you always have the most recent, because this does come from the Colorado Department of Labor and Employment and is an administrative law versus a statute. So it does change quite frequently. So minimum wage. Colorado has increased our minimum wage quite significantly. In 2016, the state passed a law that ties the minimum wage to kind of the cost of living and what's going on. So the state recently announced that starting Jan 1, 2022, the minimum wage for the state of Colorado for regular employees will be $12.56. Tipped, it'll be $9.54. If you have employees who work in the city and county of Denver, or who work from home in the city and county of Denver, you do need to be aware that the city and county of Denver has a significantly higher minimum wage of $15.87 starting on January 1st. I've also put the federal minimum wage. Obviously, the state of Colorado is significantly higher, but I did want you to be aware that there is a federal wage. Colorado's is the minimum wage you do need to follow. So overtime. So again, under the Comps 37, employers must pay 1.5 times employees' regular rate of pay for any work beyond 40 hours per week, 12 hours per day, or 12 consecutive hours. Hours in 2 or more weeks can no longer be averaged. At one point that was allowed, it's not allowed anymore. And you cannot pay comp time instead of overtime. You actually have to pay overtime now. We always advise people, make sure your week starts on the same time every week, and then monitor your employees. The other thing to be aware of are both rest and meal periods. So meal periods, 1 30-hour meal period for all shifts over 5 hours. During that 30-hour meal period, your employee cannot do any work-related tasks. They can't be checking the mail. They can't be doing anything like that. They need to have a full break from all work-required tasks. I know we tell our paralegal, go take a walk, get on Facebook, do personal stuff. It's a great time to, call. Excuse me. It's a great time to call if you have a doctor's appointment or something of that matter. Please use that time. And then the other thing is rest periods. So depending on how long a person is working will depend on what their rest period is. So they're right here. 2 or less is 0, under 2, over 2, under 6 is 1, over 6, under 10 is 2, over 10, under 14 is 3, over 14, under 18 is 4, under 18, or over 18 and under 22 is 5, and then over 22 is 6. Obviously, if you are hiring somebody, if somebody is working more than 12 hours, not only do they need these rest periods, but then you will be paying them overtime. So in exempt employees, this is the way we all work to make sure or this is the way employees get exempted to overtime, meal periods, rest periods, minimum wage. Under Colorado law, these are the main ways that you can make sure somebody is exempt. If they do not fit into one of these categories, I highlighted the main ones we see and the other ones are listed at the bottom, then you must either pay them overtime, meal periods, rest periods, or minimum wage. So this is something to be aware of, that you're classifying your employees correctly. So the first one we see a lot is administrative employees, and that employee must make a minimum salary, which will be in a couple of slides, and regularly performs duties to decision making of executive employees. So this is secretaries, administrator, people who control the calendars or work directly with people who control companies. This is again the secretary, admin type one. The next one is executives or supervisors. Again, they must make the minimum salary, and they must spend at least 50% of their time supervising employees. If they don't spend 50% of their time supervising employees, then you can't lump them into this executive category. Professional employees. A lot of people like to lump everyone into professional employees. Unfortunately, not only do they must make the minimum salary, except for lawyers, doctors, and teachers, those are the 3 that are exempt from this, they must also be in the field where their degree is and actively working with using their degree. So if you have somebody with an accounting degree and they're now working in HR, you might not be able to lump them under professional employees. Another big one we see is outside sales. The outside salesperson must work primarily away from the main location, so you can't require them to come into the office day and spend at least 80% of their time on sales. Finally, the big one is owners and proprietors. Owners and proprietors do not have to make the minimum salary, but they do need to own at least 20% of the company. So if you have an owner with 5 or 10, maybe 15, that person cannot fall under the statute. A couple of other ones I just listed just so everyone can be aware are taxi cabs, in-residence workers, volunteers, work study students, elected officials, and highly technical occupations. They're all very specific rules for these. I just figured these aren't as common as the other ones. So if you do have any questions, I will provide that link to Comps 37. The other type of exempt employees are listed below. These are only exempt from overtime. So you still have to make sure they're getting minimum wage, that they're getting rest periods, and that they're getting meal periods. So you can have 2 sets. So you need to make sure that you're following the rules for each set. These are salespersons and mechanical sales, commission sales, ski industry, medical, transportation, 8 and 80 rule. While I previously said that you couldn't do the overtime over 2 weeks, they have exempted hospitals and nursing homes for that. And then drivers and drivers helpers. These are the main exemptions in Colorado. There really aren't any. So if you have an employee who doesn't fit into one of these, then you need to make sure that they are getting meal and rest periods, overtime, and obviously minimum wage. So earlier I mentioned the salary threshold. Colorado has caused this to go up drastically over the last few years. As of July 1, 2020, it was only a little under $36,000, and then it's stepping up in these $5,000 increments up until January of 2021, and then just like minimum wage, it'll be adjusted based off the CPI. So for 2021, so for this year, your exempt employees must be making $40,500. For January 1st of 2022, they must be making $45,000. For January 1st of 2023, $50,000, and for January 1st of 2024, $55,000. So we are seeing a lot of businesses that might have had exempt employees in that range between 40 and 45,000 that are either having to make them hourly or having to make sure they're paying overtime and they're doing all of these other requirements. So please be aware of these thresholds. So discrimination. We have discrimination at the federal level as well as the state level in Colorado. In Colorado, our discrimination starts at employee number 1, and our discrimination statute covers disability, race, creed, color, sex, sexual orientation, gender identity, gender expression, religion, age, national origin, ancestry. Pregnancy is also in there, but it is a little different. The main thing to be aware is that if there is a disability issue, you have some flexibility, but in order to have that flexibility, there must be no reasonable accommodation. The disability actually disqualifies the individual, and the disability that disqualifies them in and of itself is not discrimination. If you currently have an employee who's disabled and they come to you with a disability issue, you must do a reasonable accommodation standard. You must engage in a good faith, reasonable accommodation. If you ever have an employee coming to you saying, hey, my back's hurting, I can't work as long of hours, or, I'm having some issues, please reach out to either an HR specialist or a lawyer, because that reasonable accommodation is a difficult standard and you need to make sure you're complying with it. If you're not, at the state level, complaint is made to a division called the Colorado Civil Rights Division, and if they find the complaint founded, kind of step in, they make you answer, they make you go through mediation, and if you guys don't settle it at mediation, then it can go through the court process. So it is very important that you are doing these correctly to avoid the Colorado Civil Rights Division looking at you. And then the federal, we've all heard of kind of the federal. A lot of the federal employees start at bigger companies, which Colorado doesn't usually comply with. So the federal starts at 15 employees. There are 3 separate laws that discrimination falls under: Title VII, ADEA, and ADA. Title VII is race, color, religion, sex, national origin, and sex gender. ADEA is age, so it is discriminatory above the age of 40. And then ADA is obviously disability. And again, you have the same good faith, reasonable accommodation conversation with disabled employees. If you're a company of over 15 and you have a disabled employee and something with discrimination happens, or any of these happen, you can be sued under federal or state law. If you're sued under federal law, you go through the EEOC, the Equal Opportunity Commission. And they step in, take a look at the case. If they find that there's reason for them to step in, they will actually pursue the case on behalf of the employee. This happens oftentimes when it's the 3rd, 4th, 5th claim. We see it with big employers like Walmart, or people who clearly are having issues. I pick out Walmart because they just got a bad verdict in a jury trial with the EEOC. So, but yeah, this is something to be aware of, that if you have a complaint and it rises to the level of an administrative action, it is very expensive. It is very hard to deal with, and it can involve paying off someone. So just please be aware of these discrimination rules. So next, we're going to talk about the Family Medical Leave Act. I believe it was in 2020, the voters approved Prop 118, and that created a paid Family Medical Leave Act for the state of Colorado. This will become effective on January 1st of 2024. On January 1st of 2023, all employees will be subject to a 0.4% tax. This tax will be collected the same way as unemployment. It'll be a payroll tax. And then employers with 10 or more employees will also have to pay a 0.45% tax. If you have less than 10 employees, then you don't hit that 0.45% tax. If you have an employee who goes out on FMLA leave, the state of Colorado will step in and pay the employee up to 90% of wages, which is up to 1,100 per week. This will serve very similar to unemployment, where the state just kind of steps in, they handle it all, they deal with it all. But you will have to keep 12 weeks of their job will be protected for 12 weeks. You must keep their health insurance. There are some employers who will be able to opt out of it because they provide better benefit plans than what is required under the FMLA Act. So if you're one of those, when all these rules start coming out, please be aware that you will be able to opt out. There is already a federal FMLA leave that starts at 50 employees. It's 12 weeks of unpaid job protected leave. Employer must keep insurance, and the employee must work for the employer for at least the 12 prior months. Oftentimes, small businesses haven't been offering FMLA leave, so this will kind of be a big shakeup because most small businesses are too small to fall under the federal laws, but basically all businesses with one employee will start falling under state law. So a couple of other laws that we're going to go through very quickly. The first one is the Secured Savings Act. Again, this is another law that was passed last year. It's for employers with 5 or more employees who do not already have a qualified retirement plan. The idea behind this is the state came out and found that there's about 10 billion lacking from retirement accounts. So I believe it's Jan 1, 2023. The dates have been flexible while they've been trying to get this program up. All employers who have 5 or more employees and do not already have a qualified plan will be required to sign up with the state secured savings plan. It'll be a payroll deducted IRA that'll then be given to the state, and the state will manage it on an individual basis for people. There's still a lot of questions out there because none of the rules have come out for this. Rules are expected in early 2022. I believe it's March. And then there is no required company match. I have been advising people, if you're worried about this rule, now is a really good time to go talk to a provider about a simple IRA, a 401k, or other retirement plan, so you're not having to use the state's plan. Something Hannah asked me to talk about was workers' comp. I don't do workers' comp, but you're required to have it. If you don't have it, please contact an insurance provider. Some states require it be through the state. Colorado is not that way. You can be fined. You can have penalties. You can have a lot of issues if you don't have workers' comp. So please make sure you have it. And then again, the payroll taxes, make sure you're paying FICA, make sure you're paying Medicare, make sure you're paying Colorado unemployment. Soon you'll have to make sure you're paying FMLA. I don't typically deal with payroll taxes, but if you have any questions, please contact an HR provider, a payroll company, or an accountant. They are all great resources to make sure you are doing this. So, wage transparency. While wage transparency has been on the law in Colorado for a long time, equal pay for equal work strengthened it. Under equal pay for equal work, employers are no longer allowed to prohibit employees from discussing their wage rate, discharge, discipline, discriminate any employee who inquired, disclosed, or otherwise compared the wage rate, or require an employee to sign a document that prohibits them from discussing their wage rate or deny them that ability. So you can't tell your employees you can't talk. They're allowed to talk as much as they want, and unfortunately, there's just not anything you can do about it. So we're going to talk a little bit more about employee management now. This is kind of more of the title. So we're going to go over employee contracts, handbooks, employee files, equal pay for equal work wage audits, hiring, promotions, and firing. So employment contracts. These are general clauses we recommend having employment contracts. In Colorado, you are not required to have employment contracts. We just encourage them. They allow you to set additional guidelines for your employees. And then if they were to breach those, you could possibly have a breach of contract action. The big one we consider is the non-solicitation. You don't want your employees leaving and going and starting a competing company. So you want to make sure that you have a non-solicitation for clients, vendors, employees, contractors during the entire time of their employment, as well as a period after they leave. we typically recommend 2 years for that period. It cannot be indefinitely. Another thing we highly recommend is confidential information and trade secrets protection. You want that employee to understand what is confidential information and that you're going to come after them if they take your confidential information. This is a highly litigated area, and it is much easier to litigate if you have a contract. So please make sure you're having these. Non-competes, you can prevent your employees from actively competing while they are working for you. However, it is very hard to have non-competes in the state of Colorado work after somebody has left. There are 4 exceptions to that. Buying a business, clearly not usually your employees. Trade secret protection, high-level management and their staff. I can't remember the last one. Purchase of assets. So if your employees don't fall into one of those 4 categories, then you can't prevent them from working at a competitor, even if the competitor is next door. We encourage having hours and time expectation, hourly rate or salaries. We encourage you, again, say that they're an employee at will and that this is not a statutory contract for employment. Additionally, you can request 2 weeks. They are generally not required to provide it. You want to talk about the tools or supplies companies will provide, benefits, and pay schedule, although the pay schedule can also be in the handbook. So handbooks, have one, follow it. If you don't follow it, you can get yourself into a lot of issues with discrimination and other rules. So we recommend that you not only have one, make sure your HR team and your supervisors read it and are familiar with it. It's not doing you any good if your supervisors are violating it all over the place. And the other reason to have a handbook is if you have this non-discrimination policy, equal employment policy, and anti-harassment policy, it can protect you if you are ever sued. So things we like to have in your handbook is a welcome, personal letter, company background, make them feel like they're a part of your company. Then you want a non-discrimination policy. The EEOC publishes one, that's a great one. You want a policy under equal pay for equal work and that you did not discriminate. An anti-harassment policy. Again, you want that contract disclaimer and at-will employee statement. You want family medical leave policies, paid time off and sick time policies, pay and promotions, disciplinary policies, and employee behavior. This one is very important. If you have issues with troubled employees, you want to have a very strict way you handle it and how they report those issues. For example, under the Colorado harassment law, if somebody has not reported harassment to a direct supervisor, they may be barred from bringing the complaint, but it's also important to let them know that in your handbook. Always want to make sure you have an employee acknowledgement page so you can hold it up and say, hey, they had this, they read this, they were aware. And then we also recommend holidays, payroll deductions. This is by no means an inclusive list. These were just kind of the most important. So employee files. This is a big one because, again, the law has recently changed on this. Under Equal Pay for Equal Work Act, employers are now required to keep employee files for the entire employment period plus 2 years after termination of the employment. In that file, you must have job descriptions for all positions they have had, that's under Equal Pay for Equal Work, and pay rate for all positions. Additionally, under federal law, you should have I-9 and associated documents, as well as all W-4s. You need to have these, you need to have a system, and you need to make sure they're up to date. The other things we recommend in them are disciplinary actions, reviews, benefits, contracts, kind of all those important employee things. It's Equal Pay for Equal Work has some pretty hefty punishments if you're not complying. I believe the fines are between $500 and $10,000 for the lack of compliance, as well as if you are ever sued under Equal Pay for Equal Work and you don't have these documents, you will deem to be not in good faith, and you will be subject to those liquidated damages, which are, again, as much as their economic damages, simply because their employee file was not correct. So that's kind of a pretty big incentive to make sure all employee files are up to date. So I've been talking a lot about equal pay for equal work. One important thing is these equal pay for equal work audit. Again, to be considered to be in good faith under the statute, you must perform an audit, a wage audit every 2 years. When you perform a wage audit, they must be thorough, comprehensive, with specific goals of identifying and remedying unlawful pay disparity. If you find a pay disparity and do not fix it, you will no longer be in good faith. A lot of people are recommending having counsel do this. I understand that's very expensive, but counsel does have privilege. So do be aware that if you think there is an issue and you're concerned about that issue, speaking to a lawyer is a really good way of minimizing some of those issues because it is protected under attorney-client privilege. There are also a number of HR specialists who are way cheaper than lawyers who are doing these things. So this is something to consider doing every 2 years. This law became effective January 1st of this year. As of the last time I heard a couple months ago, the Colorado Department of Labor and Employment had gotten 75 to 80 complaints. Most of them, they just explained the law. They talked to the employers. There were 7 people who didn't respond. Don't be one of the 7 who doesn't respond to the Colorado Department of Labor and Employment. They have the ability to fine you and make your life not fun. So here are a bunch of things to consider. You want to review the work each person does in your company, determine if any employees have substantially similar work. If none of your employees have substantially similar work, you just need to annotate that and move on. If they do, you need to make sure that the employees are paid any extra due to only the listed exceptions, and ensure that any additional pay or benefits is linked to that exception. You need to compare all employees with substantially similar work and look specifically at sex and all of those other factors that were listed under Sex Plus. If there's any disparity due to sex or Sex Plus, immediately fix it. And then document. Documentation is your best ally in this process. What you did for each of these steps, how you did it. And again, if you have any questions, please contact legal counsel or other wage audit providers. It's not cheap, and I understand it's not cheap, but if you were ever to violate it, the liquidated damages is quite a provision. So hiring practices. Again, under the Equal Pay for Equal Work Act, Colorado changed the hiring practices. Employers must publish the range of salary on all job postings or an hourly rate, and it needs to be reasonable. You can't say $10 to $50 an hour. It needs to be, $15 to $20 an hour, reasonable salary. And employers are no longer allowed to do any of the following: seek the wage history or rely on the wage history of a prospective employee, or discriminate or retaliate against any prospective employee for failure to disclose their prior wage rate. Do not ask. Make sure your HR department knows to not ask. This is a very easy way to get in trouble under Equal Pay for Equal Work. And then when you're going to hire, create a standard policy, write a good job description, and ensure any biases or discrimination are not part of HR's decision. So I-9, this is a very important document. We'll keep it kind of limited. I-9 is the document that all employers and employees must complete prior to employment starting. In addition, employers need to pick up a copy of the required documents or get a copy. It can be a driver's license and a social security card, a passport or permanent residency card, a foreign visa with a work permit. You are then required to keep copies of all documentation. If you were to ever be audited by the federal government, they would want to see that you checked all of these I-9s. So again, another law under Equal Pay for Equal Work is opportunities for promotions. Now all promotions must be made to employees at the same time through an announcement, post, or otherwise known. These are for promotions for big steps, not for little steps. There are a couple of exceptions to that. The one that always jumps off the top of my head is if you're firing someone, then you do not need to promote. You do not need to list this promotion. These announcements need to be made to all employees at the same time, and you must disclose the hourly or salary compensation. The best practice is to do this in a way you can record. So just make sure you're, again, with these promotions, letting all of your employees know that there are opportunities to be promoted. Firing. So in the employment world, we kind of have two types of firing, not for cause and for cause. Not for cause are your traditional layoffs. They're the, hey, we can't afford somebody, we have too much staff, you know, they've done nothing wrong, they're just not a right fit. When you're doing a not for cause firing, you need to make sure, A, there's no discrimination in layoffs. Both, there's specific laws surrounding age, but you also need to make sure that you're not going after any minority status as well, or other. The other thing we always recommend for firing is a severance agreement. So in exchange for some amount of money, they sign away all of their rights to sue you in the future. If you offer the severance agreement to somebody, you do have to give them the ability to speak to counsel as well as a specific statutory time to think about it. The other thing is your employees are allowed to collect unemployment, and you cannot make them waive that. So if you fire someone, you know, make sure you have this for not for cause, the severance agreement, and then they get to go collect unemployment. For cause, this is your bad behavior. If you're firing an employee for cause, you want to make sure you're following your handbook. You want to make sure that all issues are documented, and you want to make sure that those are kind of the big ones. You want to make sure somebody doesn't come back and go, hey, I wasn't fired for cause, I was fired for a discriminatory reason. And that is why it is very important to follow those handbook procedures. So how to terminate. It's never fun. No one likes to do it, but here are some kind of tips and tricks we've seen. Have a meeting with person in HR or other supervisor. Please be respectful. This is hard for everyone. You must have their final paycheck ready and hand it at the meeting, or do a direct deposit. And that must include all PTO and vacation. We generally recommend handing a check if possible. You can request that they provide copies of all passwords. Require them to turn in all company property, including computers, cell phone keys. Make sure you're getting all that stuff back for them. If they have signed a non-disclosure or other contracts that require them to keep confidential information, re-provide them to them and say, hey, by the way, you signed this non-disclosure agreement, you were still bound to it. And then if you decide to provide a severance agreement, request that they take time and review it and speak to an attorney. So I will now open it for questions and answers. So Hannah, whenever you're ready, if you want to read them.
Yeah, feel free to speak up with any questions. We don't really have any in the chat quite yet. I think everyone was focused on getting all this great material. So if you do have questions, you can put them in the chat, or feel free to take yourself off mute and ask verbally.
I just would like verification again about the PTO, because you said at one point that we were not required to pay out that. And then on the end where it says the check, you said to make sure you include the PTO. So can you verify that?
You're not required to provide it, but you are required to pay it out. So I'm sorry, I think I might have flipped up a little bit. So PTO, you are not required to provide, but you are required to pay out, and you're required to let employees accrue for 1 year. Whereas in sick time, you are not required to pay out, and you also have to let employees accrue those 48. So does that clarify your question?
So which one is it by state law that we're required to start providing? Is that sick leave or is that PTO?
That's sick leave, but if you provide PTO, you must pay it out at the end. So you must provide 1 hour of sick time for every 30 hours of time worked. And you do not need to pay that out if you terminate an employee or if the employee is quit.
So there's no mandating of PTO time?
No, there's no mandating of PTO time, but if you choose to provide it, you must let people accrue it up to 1 year, and you must pay it out, but you are not required to let people, you're not required to provide it.
Great, thank you.
Hey,
oh,
sorry, just to clarify, so you said that you're required to let them accrue it for a year. Is that just a year's worth of PTO?
Yes. So you're required to let people accrue up to 48 hours of sick time and up to a year of PTO. So if you, for example, say you give somebody 10 hours a month, you have to let them accrue 120 hours before you can letting them lose it.
Gotcha. Okay. So whatever that cycle of accrual is, you have to allow it for up to a year's worth of accrual before you can cut it off.
Yeah. And then you have
Okay.
to, again, pay it out. So that's why I always tell people, like, be ready to pay that out if you're terminating someone or if someone quits.
Gotcha. Okay.
A question that was typed into the chat is about the required breaks you mentioned. They ask if those are 15 minutes. And I think maybe the slide had shown that the length required depends on how long their shift is. Can you elaborate a little on that?
Yeah, I'll have to go back and look at the amount. So the number of breaks you provide somebody depends on the number of hours working. You guys will get a copy of this. So if somebody works for more than 5 hours, they have to have a lunch plus a break. And then if they work for, I believe it's over 22, they get 6. So you have to look at the number of hours and then you have to give them those 15-minute breaks.
Great, thank you. And how does that, do you need to have anything in place like for employees who are working remotely and you don't know when they're taking breaks? Is there any recommendation you have for making sure you're covered in that way?
So if you have a time card and people are keeping a time card while working remotely, then just have them put those break periods in. At the end of the day, you're not watching them, so you can't make sure. A lot of remote employees are falling under exempt. So then if you again have one of those exempt employees, depending on the type of exempt, you don't need to make sure they're doing those meal and break periods.
Great. I know in other webinars, we've focused a lot on the difference between employees and independent contractors. Do all of these only apply to employees, or is there any crossover with any of these laws to independent contractors?
None of these laws focus on independent contractor, but that does not mean go make all of your employees independent contractors. So these are just for employees. Independent contractors are not included in these.
Great. Awesome. I think those are most of the questions. If anyone has any last burning ones, feel free to type those. Oh, here's one that just came in, a little bit longer one. Okay, so here's a situational one. So for example, being in childcare where a teacher is in a room for 8 hours a day, they legally get an hour lunch break, but are they also allowed 2 10-minute paid breaks outside of the classroom? This has been a big thing that's been talked about, and how would that go into working for nannies and breaks?
So nannies, in my opinion, there's an in-home services. I don't know that part of Comps 37 very well. Depending on how it's working, they would probably be in that Comps 37. At the end of the day, a lot of nannies are under board, so they're not even complying by these rules anyways. I would have to go back and look at the Comps 37 to see if they are included in the in-home services.
Great, thank you.
I have seen an awful lot lately about tax write-offs and people suggesting that they hire their own children to work. Can you kind of give us a little rundown on how that works?
So I'm not a tax person. I can't actually give you tax advice. That's a great accounting question. Generally, don't commit fraud. If your children aren't working for you, don't hire them.
Good rule of thumb.
Don't commit fraud generally, but if you have specific questions on hey, in this circumstance, I have a child working for me who is, actually working, that is 100% an accountant question. I don't deal with tax credits.
So is there any special rules though that would make them exempt or something from some of these other rules? Or would we have, do you have any, as far as if your own child is working for you, is there any exemptions, or are you looking at following all of these rules?
You're looking at following all of these rules. There is some carve out for minors. I'd have to go back and double check exactly what those are, but generally all employees are covered the same. And if you hire a child at a special, wage, then you're also in violation of equal pay for equal work. So it is something that you do need to treat children the way you treat all other employees.
Great. Sorry, just reading some of these. Oh, here's a good one. What about internships?
So internships are, again, one of those exceptions that we're kind of listing at the bottom. If they are required or a work study, they can be exempted from this law. It just, again, depends on the exact specifics of that internship and what is going on. So a lot of these, this is kind of the hierarching. You know, if you have a specific person who's on an internship, that's a very fact determinative question.
Great, thank you. There's also a question about, are you able to utilize in-house training with certifications, et cetera? Are you able to classify them into the professional category?
Generally, it's education. I think if it were the right type of training, yes, but you would have to be very careful and make sure you were complying with the Comps 37 language. Again, it would be just a very fact-based analysis.
Great, thank you. Great. Well, it looks like those are pretty much most of our questions. So thank you for everyone for sharing those. And thank you so much, Catherine, for sharing all of your information. There's a lot that goes into this. So like we mentioned, if you do need to talk more in depth about specific situations and get some education, we do have legal consultants, Catherine being one of them, that can help with these types of things. And just a clarifying statement, I guess, to put out there about our legal consultants is they cannot give specific legal advice to your situation, but are so great about giving education and guidance as to what the law means, what that means for your situation. I know there were a couple more questions maybe for people who jumped on a little bit later. We will be sharing this recording and the slides and the materials. We'll get that out to you later this week. So I think that's everything. Thank you all for joining. And Catherine, do you have anything else you'd like to share?
No, if anyone has any follow-up questions, anything specific, please reach out to Hannah. I also put my email address out there. We do offer free initial consults. Anyone who knows me loves, I get very excited about sharing the law. Please feel free to reach out to me. There's been a lot of changes out there, so I just want to make sure people are doing it right before bad things happen.
Yes, always good to do it the right way first.
It's a lot cheaper.
Yes, yeah, definitely. Awesome. Well, thank you, everyone. We hope you have a great rest of your day.